Linkating v. Kumlik. Facts. Petitioner filed a petition for the disqualification of Sasaeng, pursuant to 40 of RA 7160, which disqualifies from running for any elective local position those removed from office as a result of an administrative case. It appears that Sasaeng had previously won as mayor of Le Quyen on January 18, 1988. In the May 11, 1992, and again in the May 8, 1995 elections, he was re-elected. In a petition for disqualification, petitioner alleged that in 1991, during his first term as mayor of Le Quyen, Sasaeng, along with a municipal councillor of Le Quyen and several other individuals, was administratively charged with various offences, and that, on February 4, 1992, the Sangguniang Panlalawigan of Sambuanga del Sur found him guilty of the charges and ordered his removal from office. Petitioner claimed that this decision had become final and executory, and consequently the then Vice Mayor of Le Quyen, Vicente Iming, took his oath as mayor. The Kumlik was unable to render judgment before the elections. Sasaeng was voted for in the elections and he won as mayor. The Kumlik then rendered a decision declaring Sasaeng disqualified as he was guilty of violating the Anti-Graft and Corrupt Practices Act. Sasaeng filed an MR contending that the decision has not become final and executor as the final disposition thereof was overtaken by the local elections of May 1992. The Kumlik en banc, however, reversed. It ruled that while it is true that one of the disqualifications from running in an elective position is removal from office as a result of an administrative case, said provision no longer applies if the candidate whose qualification is questioned got re-elected to another term. The re-election of Sasaeng in the 1992 and 1995 elections would be tantamount to a condonation of the Sangguniang Panlalawigan decision, which found him guilty of dishonesty, malversation of public funds, etc. Granting said decision has become final and executory. Moreover, the people of Le Quyen have already expressed their will when they cast their votes in the recent elections, as evidenced by the results which found respondent Sasaeng to have won convincingly. Issue 1. Sasaeng was entitled to occupy the office thus vacated. Held yes ratio, we stated in Reyes. Petitioner invokes the ruling in Aguinaldo v. Kumlik, in which it was held that a public official could not be removed for misconduct committed during a prior term, and that his re-election operated as a condonation of the officer's previous misconduct to the extent of cutting off the right to remove him therefore. But that was because in that case, before the petition questioning the validity of the administrative decision removing petitioner could be decided, the term of office during which the alleged misconduct was committed expired. Removal cannot extend beyond the term during which the alleged misconduct was committed. If a public official is not removed before his term of office expires, he can no longer be removed if he is thereafter re-elected another term. This is the rationale for the ruling in the two Aguinaldo cases. The case at bar is the very opposite of those cases. Here, the decision in the administrative case was served on petitioner and it thereafter became final on April 3, 1995, because petitioner failed to appeal to the office of the president. He was thus validly removed from office and, pursuant to 40 of the Local Government Code, he was disqualified from running for re-election. It is noteworthy that at the time the Aguinaldo cases were decided there was no provision similar to 40 which disqualifies any person from running for any elective position on the ground that he has been removed as a result of an administrative case. The Local Government Code of 1991 could not be given retroactive effect. However, Reyes cannot be applied to this case because it appears that the 1992 decision of the Sangguniang Panlalawigan, finding respondent Sasaeng guilty of dishonesty, falsification and malversation of public funds, has not until now become final. The records of this case show that the Sangguniang Panlalawigan of Sambuanga del Sur rendered judgment in AC No. 12-91 on February 4, 1992, a copy of which was received by respondent Sasaeng on February 17, 1992, that on February 18, 1992, he filed a motion for reconsideration and/or notice of appeal, that on February 27, 1992, the Sangguniang Panlalawigan required Jim Gating, the complainant in AC No. 12-91, to comment, and that the complainant in AC No. 12-91 has not filed a comment nor has the Sangguniang Panlalawigan resolved respondent's motion. The filing of his motion for reconsideration prevented the decision of Sangguniang Panlalawigan from becoming final. While RA number 7160 on disciplinary actions is silent on the filing of a motion for reconsideration, the same cannot be interpreted as a prohibition against the filing of a motion for reconsideration. Thus, it was held that a party in a disbarment proceeding under Rule 139b, 12 can move for a reconsideration of a resolution of the Integrated Bar of the Philippines, although Rule 139b does not so provide. Although Rule 139b 12 makes no mention of a motion for reconsideration, nothing in its text or history suggests that such motion is prohibited. It may therefore be filed. Indeed, the filing of such motion should be encouraged before resort to. As a matter of exhaustion of administrative remedies, to afford the agency rendering the judgment opportunity to correct any error it may have committed through a misapprehension of facts or misappreciation of evidence. There is thus no decision finding respondent guilty to speak of. As Provincial Secretary of Sambuanga del Sur Wilfredo C. Mafranca attested, the Sangguniang Panlalawigan simply considered the matter as having become moot and academic because it was overtaken by the local elections of May 1992. Neither can the succession of the then Vice Mayor of Lapuan, Vicente Iming, and the highest-ranking municipal councillor of Lapuan, Romeo Tan, to the offices of Mayor and Vice Mayor, respectively, be considered proof that the decision in AC No. 12-91 had become final because it appears to have been made pursuant to 68 of the Local Government Code, which makes decisions in administrative cases immediately executory. Indeed, considering the failure of the Sangguniang Panlalawigan to resolve respondent's motion, it is unfair to the electorate to be told after they have voted for respondent Sasaeng that after all he is disqualified. Especially since, at the time of the elections on May 14, 2001, the decision of the Sangguniang Panlalawigan had been rendered nearly 10 years ago.